Hey, you. How are you? Good. How are you? I'm very good.
Just going through everything regarding the conversation.
So we're just finishing 4,000 barrels and
Because exactly you're gonna take a
Oh, well, good. Now I know.
Jake's going. Jake's going.
Yes. Yes. Thank you. It's not, it's easy to share.
a bit more organized movement through this process. Okay, thank you very much. We've asked Director Lepore to take us through this document as the staff has prepared. We will go section by section. If there are items commissioners want to, we will approve sections where we can. If there are items commissioners want to comment, suggest changes and so on and so forth, then you can bring those up at that appropriate time. So Mr. Lepore, I'm going to totally turn this over to you.
Only for procedures, Mr. Chairman.
And then I guess we will start on page 1 of 15, 300 series. Is that correct?
I think we have resolved the issues on page 1, Mr. Chairman.
Well, we have as long as we're okay. I mean, this is, not the 90-day period. Notice must be delivered to, we haven't actually, or I don't remember, maybe we did we? I don't think we actually.
So moved. 305, big A, little a, there was a vote and it did pass.
Okay,
And the same is true on the top of page 2, subpart 2. We did not have a specific vote on subpart 3 or the next one below that, 2 at the top of page 2. So can I keep up here?
okay. So we need to have a vote on 305, big A, 3. Is that correct?
The top 2 purple provisions, the strikeout, the surface owner, and then the operator must deliver. And then we'll start doing it section by section.
Okay, commissioners, is there any, well, you have a motion to approve the 305 big A 2 deletion, strikeout, and 3, the section that says the surface owner of the lands on which the large UMA facility is proposed.
So moved.
We have a motion?
Second.
And a second. Discussion. All those in favor say aye.
Aye.
Opposed, same sign. And then we'll move immediately to paragraph 2. The operator must deliver the notice by hand delivery, etc. Any a motion to approve that? Or
So moved.
We have a motion
Second.
and a second. Discussion. In favor, aye.
Aye.
Opposed, same sign. That's unanimous. Now then, we're at little b. We've covered some of this.
Yes, we have. So, Mr. Chairman, I'll just direct your attention to subparts 4 and 5 that are strikeouts. 1 is a strikeout pertaining to proximate local governments. The proximate local government part has been moved to a different section. We'll get to that shortly. And then the offer to meet with the surface owner has also been moved to a different section. So these are fundamentally reorganizational changes.
So we need to approve the strikeouts on 4 and 5.
So moved. Second.
Discussion.
Mr. Chair,
Yes,
friendly amendment. Can we just approve that subsection B in its entirety as presented?
we can do that. We've addressed some of that, but we can go ahead and do the whole thing. That's fine. Oh crap, did we have a motion?
We did, so I'll move to amend the motion to accept Commissioner Walk's amendment.
Good, and a second to that
Second.
friendly sort of amendment. Then any discussion? Those in favor, aye.
Aye.
Opposed, same sign. We have unanimous agreement.
Thank you, Mr. Chairman. I would adopt Commissioner Wolk's methodology and look at C in its entirety. the first change at the bottom of page 2 is that insertion of the operator inviting the surface owner to participate in the consultation. I think the rest of that is pretty self-explanatory.
This is with, so you're all of little c, correct?
All of C.
All of little c.
And
So
that would
that includes the revisions of what Mr. Matter said at the end of item 4.
That is correct. And I thought we had already voted on that, but
We did.
voting on it twice, as long as we vote the same way. Sorry.
So moved.
Second.
Motion and a second to approve little c. All those in favor, aye.
Aye.
Opposed, same sign. So that carries
Do
unanimously.
you want the mouse? So we'll go to subpart D, which begins at the bottom of page 3. This used to be meeting with proximate local governments. It's now meeting with the surface owner.
Move approval as written.
We have a motion and a second to approve that as presented. Any questions, comments? All those in favor say aye.
Aye.
Opposed, same sign. So that carries unanimously. Section little e.
Section little e, beginning on page 4. Now, this is all new with the final draft. So what I propose is that we look at subsection 1, A through C. There was a D addition to this, and this is a place where looking at our staff slides might help. It has all of the language of D. This is also a place where industry is proposing an exception for existing surface use agreements, just so you're clear on that. I would propose that we consider A, B, and C at this time. Those are the first 3 exceptions. One is the opt-out provision. The other is that the operator and the operator and the local government already have an agreement. The third is the vested property rights exception.
Okay.
I have a question regarding C. Is it timely, Mr. Chairman?
I'm sorry, the question was?
I have a question for the director regarding C,
Yes, sir.
the vested rights exception. The large UMA facility is proposed to be located within the site-specific development plan as a large UMA facility as newly defined, or just as a potential location of surface development, subsurface development? And what's in that site-specific development plan? Does it matter?
I think the intent, Mr. Commissioner, was that if an operator has this vested property rights where there has been an oil and gas location proposed, then the fact that it's an UMA doesn't change that that's where they have an agreement with the local government to be, so that they skip the notice and consultation. I also, it's very, very important that I point out that the March 1, 2016 date as written here we propose getting rid of that because we think future agreements should apply, future of these vested property rights.
Yeah, the latter part certainly makes sense. The local government will be the entity determining if there's if rights vest due to approval of a site-specific development plan. I'm not sure I understand the answer to the first part, however, if it did, did rights vest around a site-specific development plan that contemplated this level, a certain level of development?
Are you suggesting that we delete the March 1, 2016 before we approve this?
Yes, sir.
Okay, we have that suggestion. Any motions to that effect? Commissioner Allward?
I just wanted to make sure that Commissioner Spielman's concerns were addressed as to just what this development plan encompassed or envisioned or whatever.
I don't know the answer to that. It seems to me that if a company and a local government have an agreement in place that going forward, this is where we're going to do this development, then that would suffice. Did I oversimplify or I have no idea what?
I think that's right with regard to the vesting. I think
Yes.
the operator is entitled to rely on the prior approval. And maybe it's just a matter of common law and compliance as to whether it's substantially similar or not. And probably not, well, I don't know. It's probably suffices the way it is. I think vested rights are vested property rights, and the going forward piece is easy, and I think the retroactive piece is not something for us to wade into. Thank you. I asked and answered. I appreciate it. Thank you.
Now, the question of deleting the date. In other words, if going forward, they can put together an agreement, that will suffice. Doesn't have to be done before March 1, 2016.
Mr. Chairman, if I may, I would move approval of that suggestion. I believe that the very process of those rights vesting gets us where the task force has asked us to look, which is that there's a consultative, iterative process between local government and the operator.
And so
So yes, I would support deleting the date.
we have a motion to delete the date
I'll
So moved.
second.
and a second discussion.
Discussion is, are we voting on 305, big A, little e, part 1, items A through C, or
We-
A through D?
A through C, including the deletion of that March 1, 2016 date.
Okay.
All those in favor indicate by saying aye.
Aye.
Opposed, same sign. It carries unanimously. Now then,
So, Mr. Chairman, I would direct your attention to the staff slides, which contain the language of D. Maybe we can get that up there. D is an exception that I think is closely related to C, that is for a different kind of approved application for development under the mineral notification statute. It's on the screen now.
okay, is there a motion?
So moved.
Motion to accept this language, a second,
Second.
and some questions? Commissioners, Dr. Allward? Those in favor indicate by saying aye.
Mr. Chairman, I'm sorry.
Oh, sorry, there is.
Is this the 1041 citation, 2465, 6455, 101? These are 1041, right?
That is not
It's the
1041.
minerals
It's
notification,
the minerals notification.
not the critical minerals. I'm sorry, I just needed 30 seconds to get my thoughts together.
Okay, we have a motion and a second. Any further discussion? Those in favor say aye.
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 Okay, those opposed, same sign. It's approved unanimously.
Okay, Mr. Chairman, back to the red line draft. We have then two additional parts to the exceptions, subparts 2 and 3. These are at the top of page 5 of the draft. One of these essentially says that the director has an opportunity to kind of verify those agreements when they're asserted as a basis for the foregoing exceptions. And part 3 says that exception from notice and consultation does not accept you from the best management practices requirements that apply to urban mitigation area large facilities.
Okay, paragraphs 2 and 3. Is there a motion to accept that language?
So moved. Second.
Motion and a second. Any discussion? Director?
A clarification, having added an exception D, we will include subpart D in part 2 where it says a Form 2A submitted pursuant to 1B or 1C or 1D would be subject to that review by the director.
Okay, with that clarification, does that change anybody's motion or second?
Nope.
All those in favor, say aye.
Aye.
Opposed, same sign. That's unanimous. Initiating Form 2A process.
Mr. Chairman, there's been a lot of reorganization of this section, so a lot of this strikeout and so forth is reorganization. Again, this is a little, I don't want to misrepresent anything. The biggest change I think here to this part is the addition of the provision that says an operator after 90 days may go ahead and initiate the Form 2A process, check the box that says we don't have an agreement, et cetera. So this was the timing question that is part of this initiating the Form 2A process. So this section sets forth a number of circumstances pursuant to which the operator can go ahead and initiate that Form 2A process. It lines up with earlier provisions. They've already got an agreement. The local government opted out, et cetera. If none of those things have happened, they've initiated the consultation process. They've been engaged for 90 days. Not yet have an agreement. It gives the operator the right to go ahead and start the Form 2A process.
So, Mr. Lepore, you're saying we take all of F in one fell swoop?
That's entirely up to you, Mr. King, and you as a commission, but for the most part,
Mr. Chairman, I
wanna
move
break it up?
subsection F.
Okay, a motion to accept, you said subsection F. And a second? Second, any further discussion? Those in favor indicate by saying aye.
Aye.
Opposed, same sign. Carries unanimously. I don't want to go too fast here. So if you have a concern, don't hesitate.
I'm trying not to hesitate right now, Mr.
Oh,
Chair. I just wanted to make sure that when we voted for E Part 2, did we also vote at the same time for Part 3?
E part 2.
Don't recall that being part of the motion, but if we did vote, if that was part of the motion, I'm okay with that.
Okay, I understood it was part of the motion, but
We did.
Okay, great.
and I think we're at 600.
Mr. Chairman?
Commissioner,
Yes, I would like to see us reiterate in the first sentence, 604C4, large UMA facilities should be built as far as possible from existing building units and operated as just the rest of the sentence is already written.
Okay, you heard Commissioner Hawkins
I'd like
make
to
a comment,
Yeah, I'd like to make a motion.
and he made it in the form of a motion that we add language which specifies or suggests that the large UMA facilities should be built as
Okay.
far
As possible from existing building units.
as possible from existing building units. Second,
Discussion.
discussion, we're just dealing with 604C4 right now.
That is correct.
Okay, discussion?
My concern is a bit wound around the axle with best available technology and would prefer that somehow worded to be technology that is technically feasible and economically practicable technology. Getting rid of the words best and available. So I would say it should be built as far away as possible.
John, would you consider if we take Director Hawkins' motion and then we'll come back?
Yes.
Would that be okay? And then, so I don't,
Well, it's a discussion because I want that
Right,
in
okay.
there before we vote on this.
you understand that at this point, we're simply voting on the motion to add language that says as far as possible from existing building units.
Can I ask a question about that?
You may,
I guess my question about that is, what is an acceptable reason for saying something is not possible? I mean, is it technical feasibility? Is it economic feasibility? What is the reason for stating that? And I just have a real concern that opens up, that just opens up a can of worms. I was trying to come up with a different term than that cliche, but I wasn't able to.
I think we're not voting on that. The words I want to add,
We're not voting on your words yet.
No.
I'm still as far away as possible.
the as far away as possible.
Yeah, that's
I'm-
what I'm talking
I don't know
about.
what does that mean?
I don't know, and that's, I have a problem.
Well, I can respond a little bit. I think this is an issue that's been brought before the commission by a number of homeowners and counties, that we have this same kind of language in our rules already, but we haven't expressly applied that to large UMA facilities. And I don't think the director excludes that from applying to large UMA facilities. I just think if you're going to clarify, this is the place to add that clarification.
Mr. Chairman, may I offer,
yes, sir.
I think it's clarification. So Commissioner Hawkins, I think what I interpreted you to say is that if you are in an urban mitigation area, so you're already within 1,000 feet, you should be as far as possible from building units within that 1,000-foot radius. So if you can be 999 feet away, that's better than 998 feet. Because if you're 1,001 feet away, you're not in an urban mitigation area. So I would just, that language, you get right. So well, I'm going to stop there. I think you understand my point.
Yeah, it may not be pushing the facility outside of the UMA, but I think if you're looking at alternatives within the UMA, it's one of the guidance provisions that we can give that we would like to see them as far as possible from building units.
Any other comments? I believe we have a motion to include that language and a second. All those in favor indicate by saying aye.
Aye.
Opposed, same sign.
Aye.
I was afraid you'd do that, okay. All those in favor, we're going to take a roll call. All those in favor of including that language?
that language being, excuse me, that language is to the maximum extent possible?
Or as possible.
As far as
Existing
possible.
building.
Is deliberation closed?
No, we were
Would
going to,
Would the move-in?
we actually were going to take a vote, and we had to switch to the roll call because we had a split vote.
Okay.
So we probably better do that, I think, or Roberts might get upset.
Commissioner Allward?
Aye.
Benton?
Nay.
Craig? Nay. Compton?
Aye.
Hawkins?
Aye.
Holton?
Aye.
King?
Aye.
Spielman?
Aye.
Wolk?
Aye.
It passes.
Seems that passed, so that's been added then to this language. Commissioner Benton had some other possible additional language.
Yes. So I get a little bit concerned about what is the best available technology and whether or not that's feasible or economic. And given our current situation for economics of the industry, I would just propose that there should be built as far away as possible, or however that is specifically worded, and operated using the technically feasible and economically practicable technology to avoid or minimize adverse impacts to adjoining land use. So you replace the best available technology with technically feasible and economically practicable.
Is there a second? Any discussion?
I'll just offer that, I'm sorry. excuse me,
Please.
Was I out of order? Thank you. Best available technology is a term that courts have looked at extensively. Other regulatory schemes use it. I think it's, whatever is written here may well be litigated. I think best available technology is a more appropriate way than the alternative proposed to proceed. Thank you, Mr. Chairman.
Commissioner Craig?
I have to go along with Commissioner Spielman on this one. To me, best available technology automatically assumes that it's technically feasible and it's got to be economically practicable. Otherwise, it's a research project. It might as well be benchtop. So to me, I don't see any discrepancy between using best technology in exchange and instead of the other.
Other comment?
How about if we call the question?
We have, call the question, then those, I'm sorry, was there another comment? Call the question, those in favor of changing the language from best available technology to
Technically feasible and economically practical.
indicate by saying aye.
Aye.
Opposed?
Nay.
Roll call, please. Those in,
There's only two. I think we're. Show of hands.
well, we have a split division of the House or something like that, and I made a gentleman's agreement with Commissioner Allward to roll call it.
Commissioner Allward?
No.
Commissioner Benton?
Yes.
Commissioner Craig? No. Commissioner Compton?
No?
Commissioner Hawkins?
No.
Commissioner Holton?
Yes.
Commissioner King? Commissioner Spielman?
No.
Commissioner Wolk?
No.
It does not pass.
Okay, that language then is not added. We're going to vote on, well, actually, let's just go ahead and vote. 604C4, those in favor of the language as amended indicate by saying aye. I'm sorry, take time out.
So I
Director.
just want to remind the commission that in the 604C4, the introductory language that you've just been talking about, the savings clause that begins no best management practices, et cetera, that has been stricken. And the draft you're looking at does not show that. That was the late change all the way to the end.
So we've included that so-called savings clause elsewhere. Or,
The savings, well, there's Rule 201 is a savings clause. So on your slides, you have the 604C4. Again, it begins no best management practice, mitigation measure, et cetera. That is stricken all the way to the end of what you see on page 7 of 15.
okay, with that clarification, those in favor of accepting the language indicate by saying aye.
Mr. Chair, just for further clarification, are we going then to the end of this or just this first paragraph?
So right now, we're just going to this paragraph. Those in favor say aye.
Aye.
Opposed, same sign. Unanimously passed. And we're at 604, big A.
Mr. Chairman, if I may,
Please.
with respect to this version versus prior versions, the next significant change is subparts E and F on page 8 of 15. Those are proposed to be stricken, both of those, E and F, in their entirety. So on your slide presentations, it looks like this.
Okay, now this is a change from what's written here.
That's right. The change after January 12th. It's now up on the screen. The prior change in draft 3 was taking out the duration limits from 604.
Mr. Chair,
Commissioner Allward?
I think with Director Lepore's clarifications there, we move to approve paragraphs A through D, large A through large D, and approve the deletion of E and F.
Second.
Okay. Okay, motion to accept the language as clarified by Director Lepore. Those in favor say aye.
Aye.
Opposed, same sign. Passes unanimously.
All right, Mr. Chairman, now I apologize in advance, but I want to take you back just a little bit and make sure everyone understands. There was another change that you voted on, and I want to make sure you know and give you the chance to revisit it. So I'm going to find it here in a second.
This was my understanding, not that.
Okay. So if you can look at your slides from our presentation, it says 7 of 15 at the bottom there. It's roughly about slide 16. This was a change in 305AF initiating the Form 2A process. In your drafts, it appears at the top of page 7. In the January 12th draft, that said that if there's a hearing on one of these Form 2As that the operator and the local government didn't agree on, the operator would be the applicant for purposes of that hearing, and the local government would be the respondent. The local governments asked that we change their status from respondent to intervener by right, so that there's not this indication that they're compelled to participate as a party respondent. So that change is on this slide. It's on the screen now. If they intervene as of right, they then are treated as if they have all the same rights as a respondent. We vetted that change. I'll stop there. But I just want you to understand that's part of this subpart F that you previously voted on. So if there's any concern about that.
We discussed that earlier. You explained it to us. So my assumption was that was included.
Okay.
Does someone have a different assumption? Thank you for the clarification.
All right, thank you, Mr. Chairman. And I'm just going to also put a placeholder in here that there is out there this existing surface use agreement exception. We're going to come back to that. We didn't deal with it when we dealt with the exceptions. We'll come back to that. So appreciate that. We are now on rules implementing recommendation number 20 at page 9 of 15 of the draft. As compared to prior drafts, the significant change was adding counties as entities with which local government, I'm sorry, I can't get this right, with operators must register with counties as well as with the municipal local governments. That's, I would suggest, should be considered first and exclusively for the moment.
Okay, that's paragraph, whatever, 1 and 2.
Yes, sir. That is correct.
Okay, we're at 302C. We're considering the language added to paragraph 1 and 2, including that that has been deleted. We have discussed it. Is there a motion?
Will these be effective by March 1st?
March 1?
I was just asking about the March 1st date, if that was still.
Might not be doable. I think the effective date of these rules will be pushing up against that or maybe beyond that. So I think that's a great point. Whether you want to give some period of time after the effective date.
May 1st requires fewer letter changes.
It's also May Day. Right.
Okay, there's some question about that date. You want to change it
Just trying to push it out.
to
a
30 days
reasonable-
after? I'm sorry, go ahead.
I was just trying to push it out to a reasonable period of time to give staff and operators enough time. So,
So you're suggesting May 1st?
sure.
Okay, there's a motion then to change that March 1, 2016 to May 1, 2016.
Do we need a date? I mean, the effective date is up on the very beginning of this rules as being 20 days after publication by the Secretary of State. Do we need a date certain? I guess I could ask my attorney.
There is a sense to these rules of this being somewhat annual. It's not explicit, don't get me wrong, but I think having a date certain that operators could look to now and in the future for this particular rule probably doesn't hurt.
Is there any objection to changing that to May 1, 2016? I hear no objection, then we'll go ahead and include that in the motion to adopt this language and ask those in favor indicate by saying aye.
Discussion?
I'm sorry.
Thanks, Mr. Chair. I just want to say, this one has really sort of befuddled me more than everything else. I don't entirely understand the exclusion of counties. That being said, recommendation 20 speaks repeatedly and explicitly to municipalities as local governments. So I am going to vote yes to strictly adhere to what I think is the intent of recommendation 20, but someday maybe someone can help me best understand what was on the task force consideration here, but I want to stick true to what I think they have indicated here. Thank you.
And the registration requirement for counties doesn't bother you enough to the recommendation may not have said counties, but
It doesn't. It says municipality repeatedly. And by the way, I think the May 1, I'm going to support that because I think it's appropriate to have a compliance period with a new regulatory scheme for folks to get up to speed. Thanks, Mr. Chairman.
okay. Those in favor of accepting this language as deleted and added with the date correction, indicate by saying aye.
Aye.
Opposed, same sign. It carries unanimously. Now we're at paragraph 3.
Yes, Mr. Chairman. And so the required information parts don't extend to county governments. To Commissioner Spielman's point, here, I think the key thing for you to be mindful of are the bracketed language about including the jurisdiction's growth management area.
Mr. Chairman,
Commissioner Holton,
we should tie that to something that's statutory like comp plan instead of growth area. Growth areas or the 3 mile plan, which is statutory, we've got to comply every year. Comp plan is every 5 years. Growth area, there is no requirement.
okay, I'm hearing some concern that the growth management area is a little bit vague, and Commissioner Holton is suggesting a different terminology.
Should be tied to the comp plan.
To the-
Comprehensive plan. The city's got to do it, and they've got to update it every 5 years.
Could you explain what that is?
It's just a comprehensive plan of where you plan on growing, kind of colors on a map about what you think the zoning is going to be. So, and it's a comprehensive plan on, you get the whole community together, then you present it to the county and they accept it. So it's more statutory. And the 3 mile plan is statutory. You've got to do that every year.
But you prefer the comp plan to that.
Comp plan.
Could you explain what a 3 mile plan is?
3 miles is where we can legally annex. And it gets updated yearly by how much you annex.
Did you make a motion?
3 mile plan would be too much. It's too much overload.
To-
So what's your motion? To tie it to the comp plan.
So including the jurisdiction's comprehensive plan? Second that.
Okay, council has reminded me that we probably need to tie that to some reference. CRS, whatever requires this comp plan. Yes, you're the mayor. Is that possible? Do you know?
I don't know it off the top of my head, and I'll tell you what I told the chairman. So a few years ago, we got in trouble because we incorporated things by reference into our rules without the required specificity. And I don't know specifically what statutory obligation you're referring to, whether it's the comprehensive plan or the 3-year plan and so on. I don't know off the top of my head.
So we'll have,
We very, I think it'd be okay if we direct our attorney to look that up and include it in the final language.
I think
No.
that gives me some concern just because I don't know specifically what Mayor's referring to. And if there's multiple sources of those sorts of growth plans, they may mean different things to different jurisdictions. And if there's a very specific statute directing municipalities to approve such plans, or more than one, I just don't know it.
Mr. Chairman, I feel like we're kind of rolling our own here, and this has not been discussed or vetted. One of the questions I would have is, you have a comprehensive plan, but there would be areas within that comprehensive plan that you wouldn't include development, or you might have more high density development. So I'm not knowing the particulars of what goes into this and how they're adopted. I'm uncomfortable just kind of at this point saying, well, it's close enough. I'd be more inclined not to go down that road and not to include in the growth management areas. Again, coming back to Commissioner Spielman's point that it was municipalities was repeated over and over, and this expanding it to growth areas is beyond the scope of the express language of the recommendations.
So you recommend deleting?
Yes, municipality. It would stay within the municipality, but not include the growth management area.
Could I ask a question, Mr. Chair?
Yes, sir.
I'm having trouble with that because I'm reading in the description of recommendation 20. It uses local comprehensive plans right in there, submission of operational information for the purpose of incorporating potential oil and gas development into local comprehensive plans. So it does sound like the task force did contemplate that. Maybe not this specific thing, and I don't know if I wrestle with that.
We did hear some testimony today from, I think, the representative from Greeley that talked about their sewer district plan, whether that. Okay, let's give me some direction. Where do you want to go? It's been suggested that we delete the bracketed language.
Is that a motion?
Mr. Chairman, I'll make the motion that we
There was a
delete
motion
the
now.
bracketed
And a
language.
Second.
Follow. Any discussion? You've heard an argument from Rich that his judgment, the intent of recommendation 20 included this concept. Okay, we have a motion. Second. All those in favor to delete the bracketed areas indicate by saying aye.
Aye.
Opposed, same sign.
Aye.
Aye. Okay. Actually, we have two nays or two opposition, Director Allward and Director Hawkins. So maybe we don't have to do the roll call, if that's okay. Thank you. All right, Director, are we at C? Give me- Or did we include that? It was our intent to include that. I don't. Did we just delete the language?
I think we just approved the deletion of the language, so maybe I'll make the motion to then go ahead and approve the remaining section here,
Okay, motion to approve.
Section
which is,
A, B,
I'm
C,
sorry,
or
A,
3.
B, big A, big B, big C.
Second. Okay, motion to approve A, B, and C as deleted or changed. Any discussion? All those in favor? Discussion?
I have a question. We've got some bracketed language that's still in here that I don't, we're in the last sentence of part A. A publicly traded company's well estimates, is that still in this language or is that included in
I
this?
think it is. The brackets have been Xed out.
Okay.
That's correct.
Okay, I couldn't tell what was going on.
And in subpart B, the brackets were Xed out of drilling and spacing orders, so those are included.
Okay, thank you.
Okay, we have a motion then to approve A, B, and C. Further discussion, hearing none. All those in favor say aye.
Aye.
Opposed, same sign.
Aye.
We have one objection, that was Director Alden. Okay, Director, I think we're 303B, 3K.
Yes, Mr. Chairman. So the conforming changes, these are changes to existing rules, essentially to make things align with the proposed new and amended rules that you've just been dealing with. I think it would be safe to take 303B3K, Roman little I, little triple I. These are procedural changes that I think are relatively non-controversial.
Would you like a motion that we approve 303B 3K Romanet 1 through 3?
Second.
Motion and a second. Discussion. Those in favor indicate by saying aye.
Aye.
Opposed, same sign. Approved unanimously. 303.
Mr. Chairman,
Sorry?
let the record reflect, please. I abstained from that one. Frankly, I wasn't ready to vote on it. So Spielman did not vote on that one.
Commissioner Spielman abstained in that vote.
Mr. Chairman, on 303C, this is timing provisions for, I think the key issue here is when an operator could seek a hearing in front of the commission on an application if staff had not approved it. So our existing rules have a 75-day clock. On day 76, an operator can ask for a hearing if we have not approved their Form 2 or their Form 2A. For large UMA facilities, the staff's recommendation is to extend that 75-day clock. And there are two extensions dependent on whether or not the operator has an agreement with the local government. Industry does not like these extensions of time. They have alternative proposals here. I think those are let's see what else is here. I think those are the key changes, and there is, as I said, some issue around these.
Okay, colleagues, what's your desire?
But I think it meant
Industry has expressed they don't like the, it was 300-day cumulative.
So I think it's 200 and we added up, was it 270 days?
It's 270, but there are some days in there that I didn't count. So there is a completeness determination that staff attempts to get done in 10 days, and I think we're pretty good at that. And there was another 30 days. So even if the operator wants that hearing, so they've gotten to the end of that clock, then there's still the notice of the hearing. So there's, before it got to hearing, there would be another, is it 30 days, 30 days, 35 days.
And probably the concern would be that the cumulative time adds up. There's a potential lease expiry issue, and you're trying to get, particularly for smaller operators, you're trying to get all your ducks in a row and get this done. Your lease could run out before you get a chance to go through hearing and get the well drilled and get the wells plugged. So I guess that would be my change to this, is that we would adopt that as I think it's 303C, 75 days for any Form 2 or 2A.
For any form,
Mm-hmm.
with no large UMA facility exception.
Correct.
Director, can you offer an explanation why, if the operator has an agreement with the local government, what would be the holdup on the commission's part?
I think there are two key considerations from staff's point of view. One is that we've extended the comment period from 20 days to 40 days. So if we're waiting to get all of the comments, if we have a 75-day clock, that basically gives us 35 days instead of currently 55 days. We've sort of taken 20 days away from ourselves by extending the comment period from 20 days to 40 days. The second is, the reality is, in these challenge locations now, we're not doing 75 days. So that was the, that's why we went from 75 to 90 days. We originally, well, I'm going to stop there. That's why. And the 150 days for the non-agreement, similar logic, understanding that we probably would spend a fair amount of time working with the operator, seeing what we might be able to do with that location to make it as palatable as possible. And you all have the industry presentations. I don't exactly remember what their proposed timeframes were, other than that they were shorter than what we proposed.
Mr. Chair, I just wanted to confirm that what we're talking about is 303C paragraph 1, that very last change of whether it's 60 or 90 or 75 days. Is that what we're talking about right now?
Yeah, 303C2, 2A, I.
You have not voted on one either. One is a specific comprehensive drilling plan situation, and we changed that from 60 to 90 days. And I apologize, but I don't know industry's position on that change. Although
And so where are the dates that that Commissioner Benton is envisioning changing from?
That would be 303C2.
Wait,
C2 Part A.
it's really 2B,
Yep.
1, little I, and little II.
Yep.
So if there's an agreement, 90 days following the determination, and if there's not an agreement, 150 days. That's when the operator may say to the staff, we're going to the commission, we need a decision.
So should we go ahead and vote on 303C Part 1? And get that behind us, and then,
Yeah, that's fine.
okay, I'll move that
That's
we,
the 60 to 90 days.
yeah, let's change it from 60 to 90 days. I'll move that we approve that.
Okay, motion to approve paragraph 1, 303C, paragraph 1.
Second.
Second, discussion. Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, same sign. That is approved unanimously. Now, we're back to 75 days, or 75 plus 90 plus 150 plus a few more, depending on when the next hearing is.
You want to ask them?
Yep, I'm sorry. Mr. Chair,
Commissioner Wolf,
I can't find what industry proposed as alternate days to each of those sections. Sorry.
okay, I don't have that. I suppose I can find that here under.
So I'm asking for a lifeline from any commissioner or staff that can find it.
I was looking for it as well, Commissioner Walk. Industry's recommended changes are summarized at the back of their PowerPoint, and the closest I can find is 303C, use current rule of 75 days for any, all caps, Form 2 and 2A.
Having just conferred with Council for Industry, that is correct. They would leave that rule as it exists currently. So it's a 75-day clock for all permits, regardless of large UMA facility.
So the 90 days that's in Romanet 1 goes to 75, and the 150 days in Romanet 2 goes to 75 also. That would be my understanding.
I think we probably wouldn't rewrite the rule. I mean, the rule has been rewritten to accommodate 3 or 4 different scenarios. We would just go back to a rule that says if after 75 days the staff hasn't approved a Form 2 or a Form 2A, then the the applicant may request a hearing in front of the commission.
So industry wants to stick with what we have now.
But we have.
Existing rule.
They want the existing rules, not what we have.
That's what's proposed.
Mr. Chair,
Commissioner Walk?
and did allied local governments or other similarly situated stakeholders propose something different for this?
I don't recall any time. See, this timeline really starts after the community. I think, my understanding is this timeline starts after the community and the company has done their consultation and they have a Form 2A to submit.
This timeline starts pursuant to earlier rules that govern when an operator may submit their Form 2A. So there's,
Which is after they've had agreement or if they haven't 90 days.
that's correct.
So did I get an answer? to my
Commissioner Allward?
question? I'm not sure I got an answer to my question. I'm sorry.
Okay, this,
I don't recall if allied local governments or other similarly situated stakeholders had comment on those days, on what staff had proposed, the 90 or the 150.
Ms. Sanchez's comment to me was that they oppose the 90-day clock, which allows an operator to submit a Form 2A before they have an agreement with the local government, which, to the best of my knowledge, they didn't comment on the 75 days versus 150 days versus 90 days.
My reading, if I may, of the allied local governments PowerPoint, the same as I just did with the industry PowerPoint, is that the allied local government scheme, the scenario or suggestion is premised on consultation happens before the 2A is even filed. So probably didn't get to 60, 75, 90, 150.
So,
Thank you.
Mr. Chair, I hadn't really contemplated some of these suggested changes, and so it's really difficult to read through the different colors and try to ignore and go back to the pre-existing rules. So I'd like to just try to understand if comparing paragraph 1 to the timeline in paragraph 2 with all its subparts, it looks to me like if a comprehensive drilling plan is in place, we're looking at 90 days. And in part 2, in a situation in which there isn't a comprehensive drilling plan, we're now contemplating 75 days. Is that a correct reading of what the result would be if we went back to the pre-existing times?
May I, Mr. Chairman?
please. Yes, sir, please.
Yes, your reading of that is correct, Commissioner Allward. The current rule on comprehensive drilling plans is 60 days for everything. We added a 90-day provision for a large UMA facility. So if you end up with 75 days for part 2, it probably makes sense to go back to part 1 and change that back to the 60 days that's there now. Although, I don't know that that was your proposal.
Sure, they wouldn't be opposed to it. We don't. So I would really have, since we've approved paragraph 1, I would have real trouble with a timeline that discourages comprehensive development plans. And so would not be supportive of shortening that time window.
Are you waiting on me?
No.
No.
No, we do not have a
It's just,
motion.
it was open for discussion.
So
So if we've already, I'm sorry, Mr. Chair,
Commissioner Walk?
if we've already approved the 90, then is there something to be said, Director Lepore, if we were going to be consistent and meet some of industry's concerns and then keep it at 90 for both Roman numeral 1 and 2?
I feel like that's something you should pose to your fellow commissioners.
Yeah, okay.
Mr. Chairman, may I?
Commissioner Spielman.
Thank you, Mr. Chairman. So perhaps the question is, at what point does an applicant, an operator, have access to decision-making? 90 days from the director in certain circumstances. There's already a comprehensive drilling plan, local comp plan compliance, et cetera. Or frankly, they don't receive that from the director and want to come to the commission. And it seems to me that, well, I don't know, it would be a question for the director. Wouldn't we have that, would we have the information, would you have the information you need at 90 days to determine if you were going to grant or deny, or if not, perhaps applicant should have access to the commission? And what I wouldn't want to do is shortchange the opportunity for a meaningful consultation process. So maybe it's, but I think that's the framework we're looking at. We've just voted to adopt 90 days to require the director to thumbs up or down. But then at what point, how much additional would be needed where there is a consultation process for the operator to have access to the commission? And to me, 300 and some days sounds excessive, perhaps. Excuse me, that was to the commission.
May I?
Do you want to respond to Andrew first and then?
I guess I'm not entirely clear that Commissioner Spielman posed a question to me. I think your framework is an appropriate framework for considering the question.
Thank you, Director.
Mr. Benton?
So reading this, the request for hearing, says 303C Part 2A, says an operator may request hearing before the commission on an application to drill Form 2 on an oil and gas location assessment, Form 2A, that is not a large UMA within 75 days following determination the application is complete. So that's fairly simple. An operator may request a hearing before the commission on an oil and gas location assessment, Form 2A, for a large UMA if the director has not issued a decision within, so let's stick with 90 days following determination of the application is complete, if at the time the Form 2A is submitted, the operator and the local government with land use authority have reached agreement regarding the site, or 90 days following determination that the application is complete if the Form 2A was accepted from the Rule 305A consultation process. It means that they opted out. The local government with land use authority waived the 305A procedures in writing, or did not timely respond in writing to the notice of intent to construct, or at the time the Form 2A is submitted. The operator and
The local government with land use authority did not reach agreement regarding the site proposed for large UMA. So to me, when I read that, this is if you throw it all in a bucket for 90 days, essentially it says, if you reached agreement and you still haven't acted on it, you can request a hearing. If you've not been able to get together and reach agreement with a local government, you can also request a hearing. That's how I read that. And so to me, I think 90 days would be appropriate because you've already done a lot of work ahead of time before you say this is just not working out. So may I put that in
The
the
only thing I'm
form of-
hearing you change is instead of 100.
Yeah.
Instead of 150, 90 days.
Yeah, so I would, and maybe we take it separately as 303C2A, which is 75 days. And then 303 large B. And then or we could take them together and we would change the 150 days in Romanet 2 to 90 days. So so your maximum is 90 days for, I don't know, I'm just.
Yeah, Mr. Chair.
Commissioner Walk.
As I think about that timing now I'm a little bit concerned now that I understand where it's all coming in, that we like CDPHE, for example, wouldn't have enough time to complete our consultation and gather all the public comment and input that we would necessarily include as part of our process if the timing were condensed.
If it were dropped from 150 to 90,
Right. Although I'll say it helped very much to have Commissioner Benton read it out loud. I must be an auditory learner rather than a visual learner, so thank you.
Thank you.
I guess I could go ahead and put it in the form of the motion and we can either vote yes or no.
Unless I get in ahead of you and put in a motion to accept the staff's language as proposed.
Second.
which one?
I only heard one more.
Okay, good.
I think
We
what
have,
I heard it was for A and B as written by the staff.
we have a motion to accept the language and a second to accept the language offered by the staff.
Discussion?
I guess we should.
Clarification, I'm sorry, Mr. Chairman, I don't mean to slow us down, but this is obviously, we all know it's important stuff, and I don't, again, I find myself just want to make sure I understand what we're voting on. The 150-day clock in 303C2C2 B 2 little I. There are 3 different scenarios in there. A determination the application is complete. The local government waives or doesn't timely respond. Or the third one is the operator and the local government land use authority don't reach agreement. It seems to me those are different time horizons. The first 2 might happen fairly quickly. The third one is the piece I was talking about before about allowing for adequate time, and I think Commissioner Walk spoke to as well. So but I also didn't understand when that 150-day clock starts. I think it's after the director makes his or her completeness determination. So I asked for clarification from the director on that.
Mr. Chairman, may I?
Please.
So Commissioner Spielman, going to go kind of step by step. Operator submits a Form 2A for a large UMA facility. We take a brief period of time to decide it's complete or not, 10 days at the outside. That's what starts this particular clock. The scenarios here, you're correct. There are 3 different ones. There was an exception under the exceptions that we've talked about. Therefore, well, enough, therefore, that there was an exception, or the opportunity to consult was given and waived or not responded to, or there's been a consultation and no agreement. Those three different scenarios. We did lump those into one bucket of this more extended time for the staff to review that. I think in all of these scenarios, our feeling was staff would need to do a more robust, thorough, complete job working with the operator on that given site. As I sit here now, I can think that might not be so true, although you raised a good question on some of the exceptions. If this vested property rights happened some time ago without perhaps appreciating the scale or the scope of the proposed development, that would be sort of the complicated scenario we would be dealing with here. But regardless, if that's how the Form 2A for a large UMA facility comes to us, any of those three things, the operator cannot ask to take it to the commission for decision until, as drafted, 150 days goes by.
Thank you.
I am really concerned about, that's 5 months. And I'm just getting concerned how long this process is going to go ahead and take from start to finish. I could see it being 9 months to a year easily, and I'm worried about that. That's a lot of time.
Would the movement accept a friendly amendment?
I'm sorry, what?
With the motion,
Maybe.
Sorry,
What you got?
I found the director's explanation very helpful. Thank you. I would offer a friendly amendment that back in 2i, again, there are three scenarios there. Two of them to me are much akin to 303C1, where 90 days should suffice. And then I would suggest we break that apart. So the third and final piece in that sentence, where the local government, land use authority, and the operator not reach agreement, that perhaps is something like 120 days.
You're talking about
Not-
303C, 2 and B, Romanet 2?
Yeah, if we can get to, my suggestion is if the director and his staff can, in 90 days, determine that essentially there's an exception that applies, it should apply to the two that are listed in 2i. The final part of 2i suggests that consultation process has not yet yielded positive results, and therefore the operator and the local government, as an intervener of right, if they wish, have access to the commission to ask for determination.
And for my clarification, Commissioner, was it you suggested 120 days under that final scenario? Did I hear you say that?
Yes.
Okay.
There's 90s or
I'm
120s.
going to wait just for a moment to see if the motion
Yes,
maker
thank you, Mr.
would
Chairman.
accept a friendly amendment from the friendly commissioner.
In the interest of time and consensus building, yes. That's fine.
Okay. And the seconder, I guess, should probably say, okay.
Do I have 120 days to decide?
No. You have 100.
I'll agree.
20 seconds.
Okay, so we have friendly amended that motion. Commissioner Hawkins.
I just have a question about what portion, let's look at it this way. If the operator has 90 days following a determination that it's complete and the local government, they've reached agreement, why should they have to wait longer if the local government waived?
They don't.
That's what he's saying.
Well, it's 120.
No, no.
It's
No.
only
He's
if
gonna
they
move
wanna-
that.
if
He's
they
gonna
wanna
move
come to
that
the
up.
commission.
Okay, so that would go back to 90, and it would only be if they didn't get an agreement.
Right.
That it would go to 120.
That's,
So that,
All right.
if
it's a
you,
request for a hearing.
All right,
Or they
I
wouldn't-
understand. That sounds good.
would you like, to the auditory learner, would you like me to read
I
this?
did.
No, He agreed to it, so don't confuse.
Don't confuse him?
No.
I won't.
I'm certainly going to support that. I have every intention of supporting that. I honestly don't know why it would take 90 days for you to check to see if in fact, for the first two items on that list. That seems relatively straightforward. So they waived the 305 provision in writing, or they did not timely respond. It seems like 90 days is a long time to respond to that.
I think clarification, Mr. Chairman. So what's happening in that 90 days is the entire Form 2A technical review by our staff.
Not just the-
Oh, the technical review. Okay, you've already said it's complete, but you have to,
Oh, yeah, it's complete means you
Gotcha.
put some marking in all the boxes is sort of what
understood,
complete
understood.
means.
No worries,
Not
understood.
reviewed.
Okay,
Right,
then
not
we-
reviewed. It's,
We have a motion.
Second.
Everybody understand the motion as friendly amended?
Just to clarify, I had intended to include section C in that so that we would take A, B, and C, in case anybody wasn't expecting that.
That's fine.
Yeah, everyone agrees to that.
Okay.
Yes, okay. Okay, all those in favor of that?
Wait.
No? We are doing some consultation.
Yeah, I think there might be some discussion of the motion.
By the way, it was pointed out to me you had a concern about the leases expiring within this long time period.
Yeah.
We always have that variance process that folks have an opportunity to avail themselves of.
Yeah.
And it seems like this might be a reasonable variance request.
Did we miss something, Director?
I can't tell. I think,
Can't or won't?
no. I can't tell whether it's related to the question you're considering right now or not.
Okay.
So maybe you can hang on half a second.
We currently have this amended motion under consideration, but we're buying a little time.
Yeah, you could repeat the motion to me, so I actually think I understand it. I think I do.
Okay, I'm going to ask Commissioner,
Commissioner Benton to read it so we all understand.
Yes, or Commissioner Spielman to make sure that we get the number in the right place.
Do we need to try it?
I'll
It'd be-
defer to Commissioner Benton. We are under the request for hearing. This is not outcome determinative. This is
Correct.
an opportunity to present a case to the commission, including both the operator and, if they wish, the local government.
So it's the request for hearing, Part 2, Capital B. An operator may request a hearing before the commission on an oil and gas location assessment, Form 2A, for a large UMA facility if the director has not issued a decision within Part I, 90 days following a determination that the application is complete. If at the time the Form 2A is submitted, the operator and the local government with land use authority reached agreement regarding the site for the proposed large UMA facility, or Part II, 90 days following a determination that the application is complete if the Form 2A was accepted from the Rule 305A consultation process. The local government with land use authority waived the 305A procedures in writing or did not timely respond in writing to the notice of intent to construct, period. Part 3, or at the time the Form 2A is submitted, 150 days,
120?
or 120 days, 120 days, if at the time the Form 2A is submitted, the operator and The local government with land use authority did not reach agreement regarding the site for the proposed large UMA facility.
Brilliant reading. I don't think we need 3 parts. I think all the 90-day parts can be part 1 and the 120-day part can be part 2. But you got all the parts together under the 90-day time frame.
I'm sure staff can eloquently combine that.
That reflects,
I'll second.
that reflects the intention
We
of
already
the
have the
motion.
motion.
We have a motion and a second, we're just
To make sure
clarifying.
we're all on the same page. Yeah. Okay.
All those in favor of this amended motion indicate by saying aye.
Aye.
Opposed, same sign. Unanimous. Now, we are at 305A. Pre-application notification, I think.
So 305A pre-application, I need Commissioner Benton. Pre-application notifications. Here, now you have a lot of new language which is related to the proximate local government notification, which proposed here would take place 30 days prior to an application, a Form 2A for a large UMA facility being submitted to the commission, and it would be directed to proximate local governments within 1,000 feet of the proposed large UMA. The proximate local government notification has been among the most contentious issues during this rulemaking. You heard from the allied local governments today, their concerns. You've heard Weld County had concerns of a different nature, et cetera, et cetera. This was moved from 305 large A to this subsection just with the final rules issued on January 12th. And I don't think there's any last minute changes. There are last minute changes. Okay, just pretty much conforming change, not too worried about it. So I'm going to stop there. I think the issue here for you is whether this is how you want to deal with proximate local governments.
Mr. Chairman, I'd move approval of the staff's recommendations for section 305A 1 and 3, as indicated on the red line.
Second.
Motion and a second to approve staff language of 305A 1 and 3. Any discussion? All those in favor indicate.
Yes, please. I think we've heard some important testimony about how the residents within the local proximate government area may be bearing the burden or a substantial amount of the burden of these large sites, facilities, and emergency response, and roads may be coming through these other proximate government areas where they have jurisdiction. And so I think we should have some discussion about this if we are comfortable with both the time allowed for responses as well as the distance. Because what we've got here right now is they would be notified 30 days prior to submitting the Form 2A. And I just want to make sure that whether we should be comfortable with this, because then I'd like the director to help me out here with Part B, capital B, the very last paragraph where the director will respond in writing. What kind of turnaround time are we looking at if the proximate local government um, commit something to you in writing, and then you will be responding in writing, how much time are we looking at in which does that proximate local government have a chance to fine tune or respond again?
I think our current process for responding to comments is within the time frame that we've just been talking about of our technical review of the Form 2A. I think you raise a fair question about whether we do that here in a more timely manner that allows, an iterative process.
So that comes in the 90-day period. Is that,
Well-
no?
During the 90-day review you're talking about.
Yeah, it does. It does. I mean, that's sort of the process now. So here, the local government gets notice 30 days before we even see the application. We have not laid out a prescriptive process here for we respond within 10 days of getting the comments or anything like that. I hear your concern about that.
And so also then, assuming that during the 90-day review period or whatever amount of time we might be looking at, the proximate local government could be continuing to interact with COGCC to fine tune things, that it doesn't all have to happen during that 30 days.
That's correct.
So we have that situation you alluded to, that I'm the proximal local government across the road from this facility where my firehouse is located. So I'm likely to be the first responder.
Right. Or the school is in the jurisdiction of the proximate government. So I want to make sure that, I think we might need a time window for the director to respond to make sure that there is an opportunity for a give and take during that 90 days of the review, that the director doesn't use 120 days to respond to the proximate local government.
Has to respond. And if I could add something, I think, and perhaps maybe you can help me and some other folks on this, that reading through this and when I read this, what I'm left with, I mean, it says there's a notice to intent to conduct oil and gas operations first specified here in not less than 30 days prior to submitting a Form 2A. And with approximate local governments, I think the concern is that I'm 30 days away from filing that Form 2A, and I'm going to just go notice that school that's across the county line. Oh, you got 30 days. I'm going to file my Form 2A in 30 days. Does that give them enough time to consider and ask for a chance to talk to the operator about what they're going to do? Or is it, I think that's where, when I was looking at this, at the allied local governments, they said the early discussions, there were 4 check boxes. It got down to the end and it said, well, it's 1,000 feet and here's 30 days notice. Is that appropriate? And that's what I'm sort of mindful of.
Well,
And then we have
we're
to
back
address the time for the director to respond as well.
And we're back to potentially adding more days to the days we just shaved off.
No, I think since the operator is notifying the local government with jurisdiction 90 days ahead of time, there's that 90-day window that we could have notification of the proximate local government anywhere in that 90 days. Right now, it's just 30 days before filing the Form 2A, whereas the local government has 90 days. So we've got 60 days to play with,
Right,
as far as when the proximate local government should be notified.
And a concern, I think, on the opposite side is that if we give them notice, there's some potential risk of, do then they have standing and can they interfere with the application process? But I think the way I interpret it is that they have the opportunity to comment and consult with.
Yeah, they don't have to.
So I'm struggling with this one. This one is not, wasn't easy to parse it out as the last one.
Yeah, I mean, I think we've seen some examples of situations in which a significant amount of the impacts could be felt by the proximate government. And I mean, I live in unincorporated Mesa County, but I could throw a rock and hit Grand Junction. And so, you know, and it's a very convoluted boundary. It's not nice, straight squares. It's very convoluted. And so in a number of cases, I mean, I can't walk the dog without going into the city of Grand Junction. And so any first responder would be probably from the city of Grand Junction. So I think we need to make sure there is enough time for approximate local government to have notification and be able to offer substantive input, because we're not giving them an opportunity to consult. So it's all going to have to go through the director, and there may be some give and take in there. And I'm sure the director has one or two other things going on at the same time. And well, so we want to make sure we have that sufficient time, and we need to talk about 1,000 feet, whether that's the right distance. And it may be. I think
You know, we have heard testimony from Garfield County and Weld County today that as a part of their normal processes going forward, they ask those proximal local governments, have another name, adjacent entities, they inform them of what's going on. And then they have a process. I don't know.
You get referrals.
Referrals. How effective that is, I have no idea. And whether or not we should even take that into consideration.
And I think if those governments have that referral process, that will, you know, work better than this. And so this is strictly for the situations in which that doesn't, those good relations, or it's not already set up. I would expect that in a number of cases, local governments have very good working relationships and don't try to surprise each other.
No, the referral system's been around for a long time, and now that Weld County is going to do the USR program, then everything's going to have to go through there. Everybody, the fire departments, the sheriff's department, the DOW, everybody gets a referral, and they've got 30 days to respond. And we do the same thing in Fort Lupton, and we've also got IGAs with Platteville and with Brighton that we exchange information back and forth. So this is just kind of redundant.
Okay, so we change it to 45 days. Does that give you any great peace of mind?
Don't we have a motion?
No, we
We don't
don't.
have a motion yet.
So I'll move, we change it to 60 days. But we've got to move it. I think we're going to have, I'm losing track of the colors and what they mean.
We do have a motion on the floor.
Do we?
Not that I know of.
I move approval.
Oh, that's right. We do have a motion. This is discussion.
I'm sorry, you did.
Yes.
You moved approval of the language as presented.
Okay. So
I thought it was seconded.
And it was.
it was
I'm sorry.
somebody.
The hour's late.
Okay. So,
No, he's we're still discussing. Yeah.
so if the, I would think it might be a friendly amendment to change the time, but you can tell me if it's not, or I'll move that for the notice to amend the motion to increase the notification to 60 days.
he's offering a friendly amendment, taking your lead. He's offering a friendly amendment. You don't have to accept that, in which case I would assume he will make it unfriendly.
Could I
You want to mediate?
negotiate the 45 days?
Only if you read it out loud.
It helps.
If 45 were offered, I would accept that from the amendment, of course.
Okay, I'll try to be friendlier than say 45 days.
Okay, there's a friendly amendment to change that from 30-day notice to a 45-day notice. And the motion maker would accept that, and the seconder
Yes.
would as well. Okay.
Should we call the question?
Just on this.
You have a question, Ms. Murphy?
Yeah, I have a question, even if Ms. Murphy doesn't. Well, staff is just a little bit concerned. So 30-day pre-application notice is something that exists in the current rules for for local governments in an exception zone and for everybody within 1,000 feet within 1,000 feet in the buffer zone. I don't think you're proposing to change those two notifications, which are 30 days. You are
No, I'm
suggesting that on an UMA application, we have a separate notice to proximate local governments 45 days ahead of the filing of the Form 2A.
That's how I understand it.
That was my intent.
So that's just going to affect our permitting process, or is that going to usurp the local government's 30 days for the permit?
I think it would give the adjacent local government an additional 2 weeks' notice in which to communicate with the director.
I don't know if that changes your process at all.
No, well, they may get their permit before then.
Okay, we do have a motion that has been amended friendly amendment. If no other discussion on that, we will ask those in favor to indicate.
Are we all comfortable with the 1,000 feet?
Okay, go ahead, we'll address that. 1,000 feet, we have, you want to, we're okay with that? The possible exception of one of us? Okay,
That was included in the motion.
that was included in the motion. Okay, thank you.
Thank you, Chairman.
All right, we have the motion as amended. Those in favor indicate by saying aye.
Aye.
Opposed, same sign.
Nay.
Okay, we have one opposition, which I believe was Commissioner Holton. Comment period. I don't see a lot of, well, there is one down there, isn't there? There's a little purple, a little bit of purple ink.
Three or 5D.
The logo.
305D, comment period, there's some purple ink on 1A at the end. I'm not sure what the implications of that are.
So to be safe, Mr. Chairman, if I may, I move to approve 305D, little d, comment period, and 306D, Part 1, consultation to occur in their entirety as written.
Second.
Second.
Motion and a second to approve 305D and 306D1. Any discussion? Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, same sign. That was unanimous, Ms. Murphy. Now, one of the things I suspect we need to do is talk about the effective date. You have some purple in there. That's at the very beginning.
Oh, and we got that.
Do we need to,
We also have to address
The effective date, purple language was really to write it in what I thought was better English than it had been written in the first time. The issue has been on the effective date that we are saying, once these rules are adopted, if there are pending Form 2As in our shop that were submitted before these rules were adopted, they're there right now, we will apply the best management practices of 604C to those pending applications. We won't go back and make them do notice and consultation again, but they should anticipate that the 604 large urban mitigation area facility best management practices would be applied, even if the application has been previously submitted.
I understand your undergraduate major was English.
Yes, sir, it was.
Nice to be able to put it to use. Okay, you've heard the director's comments on the effective date section. I'll ask for a motion to approve that language.
Mr. Chair, I make a motion to approve not only that language, but just out of completeness, section 604B, existing oil and gas locations, which I'm not sure we approved at the very end.
I'll second that.
My goodness. So that was, say it one more time, Director, 604.
B number 1, the very last paragraph, page 15 of 15, which is not part of the consultation section, so it's a separate section that we just need to approve.
I see, thank you. Okay, you heard the motion. Did we get a second? Any discussion? All those in favor indicate by saying aye.
Aye.
Opposed, same sign. That was approved unanimously, Ms. Murphy. Director?
Thank you, Mr. Chairman. I want to again try to be very clear here. 305A1, pre-application notifications, we just got done with that. There was a late addition. I'm just going to tell you, the very last sentence says the notice requirement of this subpart does not apply to local governments that received notice and accepted the offer to consult. We added that and accepted the offer to consult as a change after January 12th. I want you to know that we intended that was part of those changes. If you want to revisit it, please do so if you're comfortable then.
Anybody want to revisit that, or?
Where is that again? Sorry.
305A1, so it's on page 12 of 15. The very, very last sentence of that provision. In your document, 12 of 15, it reads, the notice requirement of this subpart does not apply to local governments that receive notice pursuant to 305AA. Do you see where I am? We inserted between notice and pursuant, notice and accepted the offer to consult. So this is eliminating the operator's requirement to give a 30-day notice to a local government only if the local government has already kind of gotten notice and consulted with them. It's really a clarifying change.
Okay, the only other item that I can think of is that we had, did we discuss that issue about surface use agreements? Goodness.
The national
Yes.
NORA surface use agreement wording and the tweaking by the staff, where that goes. I didn't know if we approved that.
I don't think you did, and I know the staff had that proposed language in the COGA's language is on page 9 of their handout, and I'm sorry, the joint industry presentation, and the allied local governments generally oppose any sort of SUA exception. But I did want to direct you to page 9 of the joint industry presentation and the language I think we can pull back up to.
Can we go? Enrique, can you go back to the narrow? Yeah, I appreciate Assistant Attorney General Matter pointing out there were many parties that had positions on an exception for existing surface use agreement. And Narrows was one you heard this morning. The industry representatives have proposals. The allied local governments have generally opposed that exception, as AG Matter indicated.
Mr. Chair.
Commissioner Walker.
I appreciate the intent, but I'm comfortable with the approved language that we previously approved that staff had provided on this section.
You're just talking about what we've accepted.
Yeah.
And voted on.
I'll second that.
Not sure that was a motion, but okay.
So Commissioner Walker or Commissioner Craig, what language would you refer to
It says surface use agreement. Just a minute.
and where?
Look at, it's page 2 of 15 at the bottom. Why is that not sufficient? Will invite the surface owner to participate in the local government consultation so the surface owner's citing requests and concerns can be considered.
My concern is that it doesn't go far enough to recognize that there's an existing surface use agreement in place. And I'm not comfortable that it would, it's gone again now, is that it essentially, that there is some deference given to that agreement during the consultation process. And felt that what was proposed by the royalty owners firmed that up a bit.
I guess my concern is whether or not that really needed to be firmed up or whether or not that could create some issues with regard to those that are getting involved in the consultation from a preemption standpoint of a longstanding surface use agreement. And whether or not we really need that additional language or that additional firming up.
I guess I would be I would opine that I would like to see language that suggests for those surface use agreements that are in place prior to the effective date of this rule, wherever possible, deference be given to those agreements. And then there was some additional language about as long as they abide by state regulations or oil and gas regulations. I've forgotten the exact nature of that language.
Could we bring that back up, please?
Enrique, yeah. Mr. Chairman, may I ask, I hope a clarifying question. To me, there's, I don't know how to say it, but I think there's a fundamental difference between an exception that if this exists, then there's not a notice and consultation process. That's my interpretation of an exception. If there's a vested property right, you're accepted from notice and consultation. That's an exception. If you have an agreement already, you don't have to do notice and consultation. That's an exception.
But just to clarify, what you're talking about though is not the SUA, it's really an agreement with the county.
Well, yeah, I'm using that as an example, Commissioner, to say what these exceptions accept you from. So if you have, and the ask here from industry is that if there is a surface use agreement signed before the effective date of these, that would accept them from this notice and consultation process. So that's one issue for you. I think that the NARO group was not actually asking, proposing an exception. It was proposing a deepened consideration, a deference to a surface use agreement if it exists. So I guess I'm trying to be clearer for myself what you might ask us to do.
I am in agreement with what you're saying. I think
Yes.
that's correct. That this language as presented, it seems to me, addresses that issue. It's not asking for an exception. It's asking that for existing surface use agreements, that the consulting parties give that agreement shall be given effect to the extent practicable. I would like that kind of language to be included.
And if I may, would the consulting parties in that you refer to, or that this refers to, is that the operator and the local government, or the operator and COGCC, or all of the above?
All of the above. I don't really like to make very many motions as the chairperson.
Well, there's a motion before us, I thought, that I made and Commissioner Craig seconded.
We either have to withdraw or vote down.
Yeah, that's true. So we're happy. They've said they're happy with the existing, what we agreed to,
Yes,
basically. Right?
and I'm unhappy in trying to worm my way in there.
Well, maybe I can make it easy and call the question, and then we can decide if we have consensus on our existing language or if we need to consider this.
That sounds like a reasonable approach. Okay, those that are in favor of the motion to accept the language as presented. I'm sorry, what was our motion again?
Just previously approved language that's already in the staff version.
Okay. To accept the previously approved language that's in the staff version, indicate by saying aye.
Aye.
Those opposed, nay.
Nay.
Nay. Apparently, we have three. Commissioner Benton. Who's the other one? Commissioner Holton, and what's his name?
The chair.
The chair. All right. Anything else, Director? We have all kinds of time. I'm not trying to rush us out of here.
We've got some yielded time we could use, right?
We have like 3 or 4 hours of yielded time.
Can we move to adjourn? Or just
Until tomorrow.
Okay,
adjourn the rulemaking?
I think we have completed the rulemaking.
Guess we'll find out.
I need to make just one comment to my colleagues. Tomorrow's hearing, I have another assignment that I have to go to, so I won't be present. I do understand that Commissioner Spielman will not be here, but we still have a quorum. Mr. Randall will be here to represent DNR's seat at the table. So everything's taken care of.
Who's
All right.
sitting in your stead?
Well, I think they're probably going to twist Mr. Randall's arm to chair it.
Okay.
Okay, thank you very much. Sorry about the confusion earlier, and thank you, Director, for bailing me out.
What's tomorrow's